We're in Hillsboro, Ohio for a pretrial hearing. 27-year-old Stevie Dawn Coulter has been charged with fifth-degree harassment, a felony. 5 months earlier, officers approached Coulter after they saw her stumbling while walking in public. She admitted that she was under the influence of methamphetamine, and when she tried to leave, she was arrested for obstructing justice and resisting arrest, both misdemeanors. Then, while in custody, she spit at and grabbed the hair of deputies, picking up the felony harassment charge. She was released on her own recognizance, but was subject to pretrial supervision, including drug testing. Today, Coulter's in court to enter a guilty plea that would include court-ordered drug counseling and potentially no jail time. She's represented by defense attorney Dennis Kerr. The judge is Rocky Koss.
Ohio versus Stevie Dawn Coulter. Are you Stevie Dawn Coulter?
Yes.
Pardon me?
Yes, sir.
Right away, there seems to be something slightly off with the defendant.
Are you all right, Miss Coulter? I can't hear you. You have a really bad headache? Anything else wrong with you? Well, we'll go ahead and have this pre-trial, but a couple things I want to talk about. I have a report from the probation department that she's been testing positive for gabapentin, marijuana, methamphetamine, amphetamine.
I just have a question. Does it even test for gabapentin on a 10-panel drug test?
What's that now?
Does it test for gabapentin on a 10-panel drug test?
Okay.
I mean, I'm a very intelligent person, and I know a lot, and I just look stuff up all the time.
Coulter then brings up what she believes is a discrepancy in her arrest report.
And in this statement from the police, from this one, it says, then I identified female Stevie Coulter, not Stevie Coulter identified herself. So he arrested me based off of...
Okay, well,
I've
that's
never
not what
met
we're
him
here about here
before.
today, Miss Coulter. It's clear that you're not in a
But they
situation.
lied also, though, Judge. They
You don't-
lied
and don't
about
interrupt me, Miss
pulling her
Coulter.
hair and everything. I was denied access to the video.
Miss Coulter,
to
be
able to
quiet.
prove it wrong.
Be quiet. Don't speak.
Because they lied.
Be quiet, I said.
They lied.
I'm not lying. I said be quiet. You understand me?
They lied.
By now, the judge seems to have had enough.
All right, I'm holding you in contempt, and you're going to be sentenced to jail for 10 days. Miss Coulter, you're disrupting this
I promise
proceeding.
you, I'm not trying to be like that.
Yeah, you're.
But it's in
yes, you
black
are.
and white. It's right there.
All right.
I highlighted it. Then I identified within the first 3 lines.
I don't even know what you're talking about because it has nothing to do with what we're here
the
for
police
today.
officer that arrested me. It was wrongful arrest, and then I had 5 cops on me.
All right, you have an
I
attorney.
had 5 cops on me.
Miss Coulter, you have an attorney.
I wasn't even being I didn't even touch that girl. It was my only form
Take
of
her into
defense.
custody, put a cuff on her.
I don't care if
Sure.
it's wrong. You're going to do trial. I want to do trial.
As she's taken away, Coulter delivers a parting shot.
I hate every person in this.
After serving 10 days in jail for contempt, Coulter was ordered to report to probation for failing multiple drug tests. But when she failed to report, a warrant was issued and she was arrested again. And then, 6 days later, according to court records, Coulter was ordered to undergo 6 months of psychiatric treatment in order to evaluate her competency for trial. Her case is pending. Next, we're in district court in El Paso, Texas for a virtual settlement hearing. 40-year-old Tony Orozco is facing a litany of charges, including burglary of a habitation, criminal mischief, and possession of a controlled substance. He could be facing as much as 22 and a half years in prison and fines totaling up to $22,000. But as the hearing begins, Orozco, who is currently free on a personal recognizance bond, is nowhere to be found. So his attorney, Daniel Avalar, asks Judge Bonnie Ronhell if they can proceed without him.
May I move the court for a waiver of presence?
Sure, of course, of course.
Avalar's worked out a favorable deal with the prosecutor. If Orozco pleads guilty to felony drug possession, he'll get no further jail time. The state has also agreed to lower his felony burglary charge to misdemeanor trespassing and dismiss the criminal mischief case. Now, the max Orozco could get would be 6 months in jail and fines up to $2,000.
That sounds pretty sweet, Mr. Aguilar. What do you think?
Yeah, I think we're about there, Judge, yes.
You want another settlement conference in 30 days?
Would you mind?
No, of course. Of course, a settlement conference in 30 more days.
The judge schedules another hearing to finalize the deal. But a few minutes later, Orozco suddenly signs into the hearing.
Okay, Mr. Orozco, your attorney just took care of your case. You're a little bit late. The hearing was at 11 o'clock, so it's 11:20. Where were you?
Downloading all this stuff.
I'm sorry?
Downloading the app and doing all this email stuff. Looking for it in the
Good idea to download it at 10 o'clock so you would be on time, Mr. Orozco? Wouldn't that have been a great idea?
It wasn't on my agenda at 10 o'clock.
Well, it better be your agenda. The next time you're late, you're going to jail, Mr. Orozco. Do you understand? So you better make your agenda to show up on time for court.
Well, I am showing up on time in court, not in Zoom stuff.
Mr. Orozco.
On my other court.
Mr. Orozco, it's yes ma'am, no ma'am.
Avalar tries to steer his client into safer waters, but Judge Rangel has already had enough of Orozco's behavior.
You're doing 3 days in jail, Mr. Orozco. 3 days in jail for your disrespect. I don't care where the heck you are. You're going to disrespect me. You're going to respect this system. You're going to jail for 3 days right now. Maybe that'll change your attitude a little bit, Mr. Orozco.
Attitude? I don't have an attitude.
Okay, sir. Think about it in jail. He's going to jail too. He has to turn himself in tomorrow, 8 o'clock in the morning for this disrespect.
But Orozco apparently doesn't have jail on his agenda either.
No, ma'am. Sorry.
Mr. Orozco, I don't think you understood what happened.
No. I'm just saying, I haven't even in my court. I'm sorry. I'm just why.
It's 6
Okay,
days.
she's coming at me like this. No.
6 days in jail. You want to keep talking, Mr. Orozco, to make it longer?
Mr. Orozco, we got you a fantastic deal. I think there should be a certain level of respect right now, okay? With the court. She's not having it right now. I think he's off, Judge.
Wow, he left. I'm telling you, people think they can give me and disrespect me and give me crap because we're on Zoom? No way. No way.
Orozco did not turn himself in the next morning as ordered, so his personal recognizance bond was revoked and a warrant was issued for his arrest. 7 weeks later, at another virtual hearing, Orozco showed up on time, but it appeared that jail still wasn't on his agenda.
Sir, I'm going to ask you to turn yourself in again.
And I'm sorry, I have a job. I have responsibilities out here.
Okay.
I mean, I know it's easy for you to ask me to do that, but it's not easy for me to do that.
Okay, sir. We'll have to have you arrested, sir.
You know, this bench warrant is for no reason. It's your personal problem that I have to go to jail. Not because of anything. I didn't do anything.
Mr. Orozco, it's not going to go very well for you, sir.
8 months later, Orozco was arrested on a new drug possession charge. After spending a couple of months in jail and not displaying any issues, Judge Rangel released him on a new personal recognizance bond with an order to attend drug treatment. Eventually, both drug charges were dismissed. And after the complainant in Orozco's burglary and criminal mischief cases stopped communicating with the district attorney's office, those charges were also dropped. Next, we go to bond court in Miami, Florida. Judge Mindy Glazer presiding. 36-year-old Adaya Baki has been charged with aggravated battery with a deadly weapon and armed burglary with assault. 2 days earlier, Baki went to a shipping store and asked for a refund for a damaged package. The manager refused, instead advising Baki to contact the seller. Baki was not happy and let loose on the manager. Surveillance cameras captured Baki punching the store manager, then following him behind the counter and hitting him several more times. Then Baki pulled a gun from his pocket.
I'm gonna blow your brains out.
As customers and a coworker fled the store, Baki pistol whipped the manager, then left the store with a warning.
I'm coming back.
Baki left behind his package, which was labeled with his name and address, so police were able to locate and arrest him the next day. Today, Baki and his attorney are before Judge Glazer to ask for his release on a reasonable bond until trial.
Mr. Delgado, the arrest affidavit alleges that this occurred behind the restricted area, I guess, of the store.
In Florida, committing an assault inside the employee-only area of a store can be considered burglary, since customers do not have permission to be there. But Baki's attorney argues his client was actually in a public area.
It's an open store. If you've ever been in one, they're all wide open. And you have to have intent to go into the restricted area to commit a crime. I mean, to refer to that as enclosed or restricted is completely ridiculous, and it's not consistent with reality. I would ask the court to find no PC on the burglary with the battery charge and give him a bond and let him post it.
Okay, state, if this is an area.
The judge, counsel's referencing a video. Does Your Honor want to see it?
Sure.
There's the cash register, the desk, and then the employee-only area that's behind the register. So it's the state's position that common sense dictates you can't go behind the counter of a business where the cash register is.
You know, I'm not excusing his conduct, believe me, but there's nothing indicating to the public that you're not allowed to enter. Right? There's probable cause for an aggravated battery and a battery, but I don't think there's enough for armed burglary with an assault or battery.
Because the judge finds no probable cause for burglary, she releases Baki on that charge. Now the hearing turns to the aggravated battery charge and whether Judge Glazer will set bond or hold Baki until trial.
Mr. Delgado, for the aggravated battery, I'm setting that bond to $20,000. It's plus house arrest with the GPS monitor.
5 days later, Baki posted the bond and was released to house arrest. He's pled not guilty to the charges, and his trial is pending. Next, we head to Inkster, Michigan for a sentencing hearing. 35-year-old Marcus Graham has been charged with a number of misdemeanors, including double parking, driving with expired plates, no proof of insurance, and invalid license. Graham is represented by attorney Samer Jadala.
At this time, Mr. Graham will be pleading to one count of no proof of insurance, one count of expired plates, one count of no operator's license on person, and one count of double parking.
Ooh, okay.
Judge Sabrina Johnson quietly goes through the charges, but Graham seems eager to defend himself.
Your Honor, if I may get a second to address the court, if you give me the right.
You can. Hold on just a second. So,
while you're writing, I just wanted to address the court.
Hold on, I'm not done yet.
Yes, ma'am. Yes, ma'am, I am. But while you're writing, I just want to address the court and tell you.
You're driving my people crazy, Mr. Graham.
Slow down. Listen to what the judge is saying. Just hold on.
Mr. Graham,
Okay.
you ever slow dance with a partner?
No.
Okay, that's why you don't know how to do this. just follow me. I'm leading. Just follow me, and then I'm gonna turn it over to you. You ready? So I'm leading.
Okay.
Just raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth?
Yes.
Great.
Yes.
Did you operate a vehicle in the city of Inkster September 25th, 2021 without a valid license on your person?
Yes.
Did you also have no proof of insurance on that date?
Yes, but I have it now.
I know. I know. And then you also, that vehicle had an expired plate, right?
But I went to Secretary of State and I have the plates now and I have proof of it.
You do. I know you do, or we wouldn't be accepting this plea. And you were also accepting a responsibility for double parking on that day. Is that true?
Yes, ma'am.
Okay. Now, what is it that you just got to tell me?
Okay, it seems like it's a long list of stuff against me. But even though it was, I took the proper steps as a responsible adult to take care of those things. I did get insurance. I did go to Secretary of State and pay the money to renew my tags. And even though I pleaded to these charges, I'm not in some I don't care attitude or it doesn't matter. I work 2 jobs. I live alone. But I'm trying to be responsible, and I just want you to keep that in mind while you pass your sentence down towards me.
Okay.
I'm sorry, I don't know how to slow down. I don't.
Times in life where you just gonna have to trust the process.
Because of his efforts to get his documents updated, Judge Johnson reduces some of Graham's fines, leaving him with a total of $605.
Okay. That's like a month of wages. Will you give me some time to pay it?
I sure will.
Okay, that's all that I asked.
Hold on. Can you take care of it in 90 days?
Yes, ma'am, I can.
Great.
Graham eventually paid all of his fines, and his case is now closed. Next, we go to Centerville, Michigan for a hearing. 36-year-old Travis Wirt has been charged with domestic violence. A year earlier, Wirt got into an altercation with his wife. Things became physical, and police were called. Wirt was arrested and released on a $1,000 bond. He pled not guilty, and a year later, Wirt was scheduled for a jury trial, but he failed to appear. The next day, his attorney managed to set up a hearing where the prosecutor was offering to dismiss the domestic violence charge. All Wirt had to do was show up and plead guilty, and the charge would be lowered to disturbing the peace. But again, he failed to appear. The next day, he arrives unannounced and asks to see the judge, Jeffrey Middleton. Judge Middleton agrees to squeeze Wirt in prior to his morning docket, and they're joined by public defender Paul Gibson.
Good morning, sir. Are you Travis Allen Wirt?
Yes.
This is an unscheduled matter, at least unscheduled for this morning. Defendant is charged with domestic violence, punishable by up to 93 days in jail and a fine of up to $500. The prosecutor has offered to dismiss the charge of domestic violence for a plea to disturbing the peace. Mr. Gibson, have you had an opportunity to discuss that plea offer with the defendant?
Yes. And he did not wish to take the plea because he did not believe that it was fair for him to be put on probation or to have to do an anger management class.
Mr. Wirt?
Yeah.
Are you going to accept the offer of disturbing the peace?
No.
All right. First of all, you're in contempt of court for you failed to appear for court on 2 separate occasions. You roll in here on a Friday morning at 8 o'clock like it's a haircut. You just drop in. You're sitting there with a hat on and no friggin' clue about how to be respectful to the court. The prosecutor's offered a disturbing the peace. You're not willing to accept it. You're so clueless. I'm going to order 2 days in jail for contempt starting right now.
Do what?
You're going to jail for contempt for failing to appear for court.
I got my dates mixed up. I have 2 different.
Well, yes, you did. So you'll have some time to think about it. So we'll set the matter for a jury trial on another day, but you're going to jail right now for 2 days for jerking the court around and not respecting the process. You don't just roll in when it's convenient for you.
I won't.
So,
it wasn't that it was
we'll
convenient. I was in contact with Gibson, and yesterday the only ride that I had up here had a heart attack.
Good morning. Mr. Wertz in the conference room. He's going with you. He gets 2 days in jail.
I was in contact with Paul the whole time too.
Then why didn't you show up for court on Wednesday when we're all here ready for a jury trial and you're not? I have to call you and wake you up. So you're gonna do 2 days in jail for failing to appear. So we'll set it for jury trial. I'll work on that with your lawyer. Stay in contact with your lawyer. I don't want you to miss another court date. But you've got a couple days to think about showing up respectfully, on time, with no hat on, and understanding there's some gravity to the process.
I didn't even know that we were doing court right now.
All right, good luck.
Wertz served his 2 days for contempt of court. Later, the complainant decided against moving forward, and the entire case was dismissed. Next, we're in Ann Arbor, Michigan for a sentencing hearing. 43-year-old Andrew Lewis has pled guilty to fourth-degree criminal sexual conduct. 3 years earlier, 40-year-old Christy Kenyon was invited out for drinks by her hairdresser, who brought along her husband, the defendant. Later that night, back at Lewis's home, Christy says she became lightheaded after eating a taco that he'd served her. She told police that the next thing she remembers is waking up naked and being sexually assaulted by Lewis. Christy reported the incident, and Lewis was arrested. Although she claims that Lewis's wife was aware of the incident, she was never charged. In a deal agreed to by the defense and prosecution, who'd gotten the approval of the victim, Lewis pled guilty to fourth-degree criminal sexual conduct and now faces a sentence ranging anywhere from probation to 11 months in prison.
Number 35, People versus Andrew Lewis.
Today he appears virtually before Judge Patrick Conlon, who will be handing down his sentence. Also on the call is the prosecutor, Christina Hines, along with the victim, who appears openly in court to face down the man who attacked her.
It has been over 3 years since the incident occurred that would forever alter my life. You and your wife invited me to a bonfire. You drugged the beer, you handed me towards the end of the night, and you drugged the taco meat. You carried my body from the living room to your bed, so insanely disgusting. You proceeded to remove my clothes and rape me. When I came to, I was beyond horrified and so confused as to what was happening. I could not move. I was paralyzed from the neck down by the drug that you used. I could not speak or scream. I lay there helpless as you raped me and did nothing. And you actually had the audacity to say to me, just keep still and it will be over soon.
That's defense attorney Ellen Michaels on her cell phone during the victim's statement.
You did this to a mom, to an innocent family. Do you understand that? You should be locked up and throw away the key. You are indeed a rapist. Your wife is your accomplice. I did nothing wrong and nothing to deserve this. Andrew Lewis, I came forward to ensure that you never do this to anyone ever again.
When she's finished, defense attorney Michaels makes a statement.
I'd like to speak to a minute about, some of the things you heard today. And Andrew's wife wasn't charged. If there was evidence that she had done anything wrong, she would have been charged. Moreover, there were tox screens taken of the complainant in this case, and there were no drugs in her system. And most drugs that give the kind of feeling that she described would have been in her system in the very short time frame of which she went to the hospital. There's been no evidence at all that that was the case, but there was evidence that she voluntarily did drink quite a bit of alcohol. And that's also part of what was going on here, is that all the parties were drinking alcohol and engaging in adult activities.
Judge Conlon's ready to render his sentence, but first he has a few words for the defense.
Ms. Michaels, I'm a little troubled by your speech there to point out how Ms. Kenyon might have been culpable at this stage of the game is perhaps not your wisest course in the future. Additionally, anytime a victim is making a statement, if you're ever in my court again and you pull out your telephone to do something with it, I'm going to stop the proceedings at that time because you did it twice. And I don't know if you're aware that your camera was on, but we all saw that. So utterly inappropriate.
The judge sentences Lewis to 5 years probation with several conditions. He has to register as a sex offender, undergo therapy, and he's prohibited from having any contact with the victim. Next, we're in Ann Arbor, Michigan for a plea hearing. 62-year-old Randall Hissler has been charged with assault on an officer. 4 months earlier, Hissler was on parole for breaking and entering when parole officer Shalimar Howard arrived to check on Hissler's roommate, who was also on parole. That's when Hissler allegedly assaulted the officer.
Recall number 12, People versus Randall Hissler.
Today, Hissler appears remotely before Judge Patrick Conlon to plead guilty.
Based on the information in the pre-sentence report, I do find that the sentencing guideline range 7 to 23 months is appropriate and supported by what's in the record. Now let's go back to you, Ms. Blanche. Do we have a victim impact statement?
Yes, Your Honor. Agent Howard is here, and she'd like to make a statement to the court.
After 20 years working for the Michigan Department of Corrections as a parole and probation officer, this is the first time that I've ever had a supervised individual physically attack me. He came at me quickly. I gave Mr. Heisler multiple verbal commands to stop and back up, but he continued to push and pin me between the door and his person in attempts to escape. I was forced to draw my weapon. When Mr. Heisler attacked, he put me in jeopardy of not being able to go home to my family. This is why I felt it was important to speak out.
Mr. Heisler, is there anything you wish to say before I impose sentence?
No, go ahead.
Okay.
Wish I could take a polygraph test to prove I'm guilty. I'm not guilty.
Okay. You pled guilty, though, correct?
No, I pled guilty, but if I would take a polygraph test, I would pass in true caution. She won't. She's lying. But go ahead, sir. Go ahead and do what you gotta do. I'm sorry. She's wrong.
It seems that although he's pled guilty, Hissler is now claiming he's innocent.
I'm gonna just take a second here to think about this. I'll be right back.
With Judge Conlon out of the room, the defendant makes another comment, this time directly toward Shalimar.
Liar.
Mr. Hissler, while we are off the record, I strongly recommend that you discontinue from the conversation that you're having with the court on this nature. It's not helpful right now, so just relax. But it's not bad to go. No, Mr. Hissler, take my advice with a grain of salt, but take a break, wait for the judge to get back on the record, okay?
After a few minutes, the judge returns.
We have gone through basically in the entire sentencing protocol all the way through to the defendant's statement to the court, wherein the defendant basically said that the victim is lying. So at this time, I cannot turn a blind eye or a deaf ear to this. So I am going to reject the plea at this time, and I'm setting this for pretrial next week, and we will see what happens.
Prosecutor Jessica Blanche immediately challenges the decision.
But Judge, why, just because he's saying the victim's lying? It sounds like after the PSI, he has buyer's remorse. The fact that Mr. Hissler doesn't want to take any accountability, and now here he is saying that it's the victim's fault. I'm asking you to sentence the defendant.
I mean, I guess in my mind, this feels to me a lot like this defendant is seeking some way to cloud this matter for appeal. But I am not convinced, Ms. Blanche, that perhaps a trial in this matter isn't a more clean way to achieve whatever is being achieved. Likewise, if I reject the plea, you're free to appeal that as well. So what I can do is this. I can adjourn the sentence 1 week, and we'll be back here next week to consider this. But, you know, obviously everybody has the right to appeal me if they don't like what happens. So, okay? So we'll be back here next week.
A week later, Hissler accepted responsibility and decided to move forward with his guilty plea. Judge Conlon accepted the plea and sentenced Hissler to 12 months in jail. He'll have no chance for early release. Next, we head to Shelton, Washington for an arraignment. 34-year-old Richard Smith has been charged with driving with a suspended license.
Mr. Smith is charged as a misdemeanor and is punishable by 90 days in jail and a $1,000 fine.
Presiding Judge George Steele then reviews the defendant's rights.
You have the right to be represented by a lawyer, and if you cannot afford a lawyer, you have the right to have one appointed for you at no expense.
A standard procedure during an arraignment. But Smith, who's appearing today without a lawyer, has got questions.
Did you have any question about those rights?
Kind of, yes. Corpus delicti in this case is kind of funky, being the state of Washington. It seems to be me to be a fictitious plaintiff. In a sense, I can't subpoena a plaintiff that doesn't exist as a person.
Okay, we're going to talk about a couple things first because what you're saying is gibberish. You don't even know what corpus delicti is.
Corpus delicti produce the victim.
No, that's not what it means.
Definitions here.
Here's the situation. I'm gathering that sounds to me like you might be kind of dabbling in the sovereign citizen stuff.
No.
Sure sounds like it.
The sovereign citizen stuff that Judge Steele mentioned refers to tactics employed by individuals who somehow believe the law is illegitimate and answer only to their own interpretation of it.
Here's how it works. Pay close attention. Simply because the fact there's no, quote, identifiable victim doesn't mean its behavior is not a crime.
The judge decides to schedule another hearing since the ticketing officer did not provide enough information in his report. The defendant simply needs to sign a document agreeing to return.
Am I being penalized if I don't sign?
I'll have you thrown in jail if you don't. Does that sound like a penalty? Don't challenge the authority of the court.
Smith eventually complies, signing the release, but he adds a line about being under duress, which irritates Judge Steele.
Let me see it.
Proceeding under duress.
Reprint the order.
The judge rejects Smith's amendment to the order and has a second one printed, identical to the original.
Sign the order. Just your name, nothing else.
I can't. That's...
Just sign the order. You're ordered to do so. If you don't, it's contempt of court. You're not under duress, but you are under court order to sign the order.
Smith signs the new copy of the order, but defies the judge and once again adds his claims of duress.
Have a seat. You're in contempt of court.
Okay.
The maximum penalty for contempt of court is 30 days in jail and a $500 fine.
I'd sign it with my rights reserved then.
Signing this does not take anything away from you, sir, as far as your rights.
Why do I have to sign it then?
Because I just told you to, because it gives you notice when your next court date is.
I'm gonna sign the order then.
You're gonna sign your name and nothing else. Anything else, you're going to jail.
Smith complies, and Judge Steele purges the contempt charge. Before things wrap up, the judge has a final word of advice for Smith.
My suggestion to you would be that you should probably spend some time having a brief consultation or a longer consultation with a lawyer.
That's pretty much a waste of my time.
Sit down. I purged the one contempt. I don't need any editorial comment on your part that this is a waste of your time. I don't care if you can believe it. And outside this court, you can say anything you want. You can tell everybody I'm the devil. I don't care. You have a right to speak. Don't say a word. But inside this court, you're going to show respect for the court. That means when you're directed to do something in the court, you're going to do it. You're free to leave.
Okay. Thank you, Your Honor.
Smith failed to appear at his next hearing. There is currently a warrant out for his arrest. We're in Eureka, Kansas for a probation hearing. A year and a half earlier, 26-year-old Daniel Lyman pled guilty to marijuana possession and was sentenced to a 6-month diversion program, similar to community service. He was also placed on 6 months of non-reporting probation and ordered to pay $658.
Daniel Lyman, are you here?
Yes, Your Honor.
Today, he appears without an attorney before Judge Phyllis Webster because he's missed the deadline for paying his fine.
You were supposed to have your case paid by today, February 6th. Now, what were you saying, sir?
The reason why I haven't had it paid yet is because the job that I was supposed to go for, it didn't plan out as planned. So I'm working at a motel over here in El Dorado, and it's just not bringing in as much money as it should.
And the marijuana charge isn't the only case that Lyman has to worry about. Shortly after his arrest, he got into a car accident while driving without a license and failed to notify authorities. That's a violation of his probation. And a year later, Lyman was charged with driving with a suspended license, convicted of both charges, sentenced to 6 months probation, and ordered to pay additional fine.
Have you paid anything on that case?
I've been slowly paying on it and everything. I try to make $10 payments. So I have owed $377. I've only paid $20 on their case so far, too.
So how come they've gotten $20 and I haven't gotten anything? Mr. Lyman, I'm going to modify your sentence. He doesn't have this paid in full in 30 days. I'd like to do a motion to revoke diversion, and I'm going to put you on reporting probation.
You know, I feel like this is really unfair on me because, you know, I've had it really hard the past few years because I do not get a break. I've not had a break since I've been 16 years old with the justice system. In the state of Kansas, I always get in trouble. When I lived in Oklahoma for 3 years, I never got in trouble. I have not had one driving ticket, nothing in the state of Oklahoma. And I just feel like this is unfair on me. Just because I can't pay a fine and I can't have a chance to do anything because I'm trying to get my life together. I promise you, I'm not trying to drive. I'm not trying to get in trouble.
Stop. Okay, you said you haven't been given a break. It looks like you were given diversion in this case initially.
Yes, ma'am.
That was a break. If you'd done what you were supposed to, the charges would have been dismissed and kept off your record. So wasn't that a break? I let you pick when you were going to pay this off, and you picked today. Then you didn't comply with that. You know, I didn't have to give you probation. So that was a break. I didn't put you in jail, right? That's 2 breaks right here in this case.
Yes, Your Honor, you are correct.
So I really don't think you have any grounds to sit here and say, poor me, Kansas is too mean to me.
Yeah, it is. It really is. If I had a choice, I would move out of Kansas right now and I would never
How can you say it's mean to you and we're giving you all these breaks and you won't quit violating the law? You have 30 days to have this paid in full.
Or else I go to jail.
You either go to jail or you get your probation extended.
This is really, really stupid.
As I understand it, he got a driving while suspended. Is that right, Mr. Lyman?
Yep, Your Honor. Because of your stupid state of Kansas.
Okay, you've just been found in contempt of court.
I'm moving out.
All right, you are in contempt of court. You have now failed to appear. We need a bench warrant for his failure to appear today. Please do a bench warrant as soon as possible, Mr. Regier.
The hearing appears to be over, but a few minutes later, Lyman rejoins the Zoom.
Hey, Your Honor, this is Daniel Lyman. Can I speak with you?
I've moved on, Mr. Lyman, but you can come down to the courthouse.
And see if I can continue Zoom court, please.
Come down to the courthouse and I'll talk to you there.
I'm not showing up.
If you want me to reconsider you, Mr. Lyman, you come down to the courthouse and talk to me.
The defendant leaves the call for a second time, and the judge issues a bench warrant for his arrest. Lyman also must still pay his outstanding fines.